Okay, we're live.
Okay. Well, it's 10 o'clock, so it's time to get started. I'm going to say a few things to set the stage here. Number one, this is a meeting of the Objections Board, we'll call it, pursuant to Kansas Statutes Annotated 25308. Specifically, subsection C of that statute authorizes the meeting that we're having today. This was brought about by an email that I received Wednesday, August 19th, 2020 at 9:18 a.m. from Tabitha Lehman, the election commissioner. She informed me that she had received an objection to the nomination of Sarah Lopez for County Commission District 2. She attached the objection, and she asked that, again, pursuant to the statute 25308, that we convene an objections board to review the objection that had been filed with her office. And we're supposed to do that within a certain period of time pursuant to the statute, and so that gave us until this morning. So pursuant to the statute, the election commissioner is supposed to be a part of this board. I think it's well documented, going through an illness right now, and so she's asked her deputy to stand in. Would you state your name for the audience?
My name is Sandra L. Greitz.
Sandra Greitz. Myself, I'm present, obviously. Sheriff Jeff Easter is appearing by phone. Sheriff, can you hear me?
I can, thank you.
Yep, so Sheriff's here, so the three of us are here, and we are making up the objection board. I'll go ahead and read, there's not really a record to read this into. This is not a hearing of record, but it is a hearing, obviously, that's being conducted in an open setting. So for anyone listening, the media, for Ms. Lopez, for her counsel who is present, Ms. Yingling is present in the back of the room, and Ms. Lopez is present by Zoom. Ms. Lopez, can you hear what I'm saying? Can you give me a thumbs up? Want to make sure. Just want to make sure she's here. Can you hear me okay? Yeah.
She said she cannot hear, but she is on our Facebook page and listening in.
Okay. Is this work? Let's ask it this way. Is it working for her at least?
Can she call in? Can she call in?
Obviously she's speaking, but I'm not hearing her either, so. How we doing? Do you have, K.S.A? So we're going to take just a second here and make sure that, she's the subject matter of this, and I think it's imperative that she not only see but hear live what's being said. So we'll take just a moment, handle this technical issue. If we can join her onto the same conference call that the sheriff is on without certainly cutting him off, that would be, strikes me as fairly easy and maybe an easier solution. She can still watch using Zoom, but as long as she can hear. Ms. Yingling, do you have her, I don't want to say this out loud for the world, but do you have her cell number you can share with them privately so they can join her in? I think your lawyer may be using your cell phone here in a moment. Well, of course, she can't hear me, so. Got it?
Sheriff, can you hear me?
Yes, I can.
Okay, can you call into the extension 9304, please?
9304, absolutely.
Okay, I'm gonna hang up and then open that line up.
Okay.
Can you ask Linda what that extension is?
Welcome to the age of COVID technical difficulties.
Had a murder prelim the other day, and we had to get the victim's family in Colorado. It took us 45 minutes to get everything set up once we got started. So it's handy, but it's
9034 is
when it works.
go to meet me. Okay, so then they need to call 660-9034.
Could you text the sheriff? I think it's 930.
Give me one sec. 9304.
Is that it?
9034.
Somebody just joined the call?
I am on here now. I apologize. I joined the phone meeting from the link that was sent with the Zoom information, but
Okay.
it just kept me on hold. So I got this number from K.S.A. So I'm here.
Very good. Sheriff, are you on?
I am.
Perfect. Okay.
And her camera is synced up with yours.
Yep, looks like. All right. Well, let's get back to where we were. So Ms. Lopez is able to access us now. She can see us by Zoom. She's got the audio using a workaround, but it works. Sheriff is with us again on the conference call. So where I left off was the reason we're here is the objection that had been filed with the election commissioner. She notified me last past Wednesday, August 19th, of the objection. Now, for the purposes of making sure this is all clear for Ms. Lopez and also for the public who's watching, the media, I'm going to go ahead and read the nature of the complaint. On August 18th at 1:55 p.m., the election commissioner received the following email from John Whitmer, Republican Precinct Committee Man. It says he wants them to consider, I'd like you to consider this as a formal complaint as to the residency of Ms. Sarah Lopez, candidate for Sedgwick County Commission District 2. I don't believe Ms. Lopez is a resident of the district, period. In fact, on many websites, she's currently listed as a precinct committee woman for PY01 for the Democratic Party. I'd appreciate it if your office would investigate the residency of Ms. Lopez. If you have any further questions, let me know if you have any further questions, and thank you for your consideration. So that was the objection that precipitated the call from Ms. Lehman to me, or the email rather, and gave rise to this hearing today. Again, the statute that authorizes this hearing or mandates this hearing is 25308, subsection C, that says we're supposed to conduct this. Well, actually what it says is objections will be filed with the county election officer and shall be considered by the county election officer, the district attorney, and an elected official of the county whose position is not involved in the controversy, who shall be designated by the county election officer. The decision of a majority of these officers shall be final. So again, Ms. Greitz, myself, and Sheriff Easter are the three that are going to compose this body today. There's no real guidance beyond that in terms of how we're to decide the case or the situation. We're simply to make a decision. I did some research and did share with the sheriff and Ms. Lehman and Ms. Greitz last week a few statutes which seem to be, and Attorney General's opinions, and even a very old case published by the appellate courts of the state of Kansas. Number one, K.S.A. 19202, Commissioner's residency requirements. It doesn't give a lot of guidance there, just says they have to be a resident of the district. What a residence means is not defined by that particular statute. There are, however, again, discussions in both Attorney General's opinions and in, like I said, this one case dating back to 1950, in fact. But the terms, the sentence, the definition that is repeated throughout Attorney General's opinions, and again in this case, is that residents, and I'm going to read this specifically from a 2001 opinion, 2001-16 from the Kansas Attorney General, which provided the following definition of residence. It reads in part, residence means the place which is adopted by a person as the person's place of habitation, and to which, whenever the person is absent, the person has the intention of returning. They have the right to change their residence, even temporarily or permanently, etc. But the question is this what they intend to be their permanent residence? And then in that 1950 case from the Kansas Supreme Court, again it reads, residence has been defined by our statute as follows. The term residence shall be construed to mean the place adopted by a person as his place of habitation, and to which, whenever he is absent, he has the intention of returning. When a person eats at one place and sleeps at another, the place where such person sleeps shall be deemed his residence. So we get a little further definition there. So that's the framework we're operating under. Finally, I would point out that we are treating this pursuant to open meetings, and the statute KSA 75-4318, subsection G1 does say that if there's some need for determination or a discussion about, say, weighing of evidence, I'll just read it here. To any administrative body, and that's what this is, an administrative body that is authorized by law to exercise quasi-judicial functions. When such body is deliberating matters relating to a decision involving such quasi-judicial functions, then an exception to open meetings would apply. So depending on what happens this morning, if there's a need for deliberation, then the sheriff, Ms. Greitz, and myself I suggest we go use the county manager's meeting room to conduct that, but we'll see how the morning goes. I'd also point out that there's a 1999 Attorney General's memo to then Secretary of State Ron Thornburg, which talks about quasi-judicial, the meaning of that term, and it's like fact-gathering, weighing of evidence, and drawing of conclusions, a body that does those things, and I think that would certainly qualify here today. So with that, my intent is to ask Chief Investigator for the Office of the District Attorney, Kelly Otis, to come and present to Ms. Greitz and the Sheriff and myself the evidence that he gathered last week. He'll describe in more detail, but when I got the email from Ms. Lehman on Wednesday, I immediately had Clint Snyder, Deputy Chief of Investigations in my office, and then Mr. Otis, the Chief of Investigations, begin to look into this, and Investigator Otis will describe here momentarily what they found. And so that's the plan. At the end of that, we'll hear from, we'll go from there. We'll start with Kelly. Is that okay with you, Ms. Greitz? Yes. Sheriff, anything else to add?
No, sir.
All right, very good. I'll stand down. Kelly, we'll have you step up here. Kelly, why don't you go ahead and state your name for Ms. Lopez and anyone listening.
My name is Kelly Otis, O-T-I-S.
Just tell us how you're employed and what your role was in this investigation.
I'm the chief investigator for the Office of the District Attorney here in Sedgwick County, and I was assigned by the District Attorney, Mr. Bennett, to initially assist Investigator Snyder with this since he was going to be out of town this week. So he and I worked the investigation together, and I'm here to inform you of the results.
Very briefly, just so that people know who did this investigation, what's your experience as an investigator before coming to work for my office?
I'm a police officer on year 35 of my career. I worked for the Wichita Police Department for 22 years, the last 11 in the homicide unit, and then came to the DA's office in 07 where I've led the investigations group here.
And very briefly, Investigator Snyder, he spent his career doing what?
Pretty much the same thing. He worked for the police department and then came over to the DA's office when he retired from the department.
Pardon me. And so the two of you were asked to look at this, and how was the investigation conducted?
Initially, Investigator Snyder just started going through the easy steps, finding out who the people were that were complaining, if possible, based upon that email. Running a check on Ms. Lopez and her history of residence. And then we started to narrow it down to basically the allegation was pretty simple, that the allegation was she was not living in the district that she's running in, and we started to narrow down on that.
You mentioned the people who made the objection. Let's get that out of the way at first. Did you speak to Mr. Whitmer?
I did.
And did he offer anything in addition to his statement made by email to Ms. Lehman that he believed that Ms. Lopez was not a resident and that he wanted that looked into?
He added just that the people that informed him of this potential problem wanted to remain anonymous, and that's why he kind of carried the ball for this.
But in terms of anything more specific evidence, did he offer anything or have anything?
The only thing he offered was that Ms. Lopez was still listed on a website somewhere, maybe the election office, showing that she was a committee person in the K.S.A. area instead of South Wichita.
Did he I have this old habit of saying, for the record, there's no record being made. We're just doing this in an open setting, but there's no court reporter here. So, but so people know, Mr. Whitmer does not appear in the court in this chambers today. Is that correct?
That's correct.
And did he express whether he wanted to be present and wanted to be heard?
With our conversation with him, he said he didn't need to be present. He just followed up with the email.
Okay. Not that he was a party to this, but Mr. O'Donnell, was he contacted as well?
I contacted Commissioner O'Donnell.
And did he express any desire to be present for this hearing tonight?
He did not.
Okay. And again, for the listeners, he's not present in this chambers today. Is that correct?
Correct.
All right. So you spoke to the two of them. Now you've moved on to the investigation. How did that begin and what was found?
Basically, we started with that website issue. Clint Snyder talked to Ms. Greitz, I believe, by telephone. And Clint told me later that he found out that sometimes names are just not removed. We learned on a follow-up, Clint on a follow-up phone call again with Ms. Greitz, that often the names aren't taken off, and then during this investigation they were, and it turned out it was because votes were counted for the K.S.A. district. She was not on the ballot, so she was immediately removed from the website at that point, from what I understand.
Okay. So you resolved the question as to her name on the website. What other steps did you take? And I should stop there. Ms. Greitz, anything to add to that? Is that an accurate recitation?
Yes.
Then we started researching the address down in southwest Wichita on Angel Street. One of the things we did initially were looking for her voter registration, Ms. Lopez. February of 20, she updated her voter registration to that address down south. And then when she filed for county commission in May, she used, of course, the same address. We contacted the postal inspector for the Wichita, Sedgwick County area and asked for any change of address that they might have on file. The next afternoon after we requested that, the postal inspector called and said that there was no change of address that he could find. However, he had contacted the carrier for Ms. Lopez's new address, who confirmed that Ms. Lopez had been getting mail there on a regular basis for a while. We also then went to the Wichita Police Department for some help with documents on utilities. And the Wichita Police Department provided documents to us that showed Ms. Lopez since February had been getting water service and paying for water service there at the Angel address. We also contacted the chief of police in K.S.A, where Ms. Lopez had previously lived. The chief was able to get to the utilities in K.S.A and said that Ms. Lopez had water service there up until February, and then it had been shut off. And now there was someone else living in that residence and getting water, but not Ms. Lopez.
I'll stop you there and just ask a couple of follow-up questions. The postal inspector said there's not been a change of address, but did he give you briefly an explanation as to how it was that according to the actual mail carrier that her mail was getting there? Did you very briefly walk you through that process?
Oftentimes, and he talked, Clint's the one that talked to him, but Clint told me about the discussion. The postal inspector said oftentimes, even if there is a change of address, sometimes they have a hard time finding it when they're looking back for months behind. Now, you can imagine how many they get. But he did contact the carrier for that address, and the carrier said absolutely, Ms. Lopez has mail coming there constantly and on a regular basis.
Okay. Okay. So you confirm water. What about, was there an effort made to any other utilities? Water, the only you could confirm?
We used to be able to get Westar records. Now they don't give those up to law enforcement anymore without a subpoena, so we did not call them. I also contacted the owner of the property who was listed under the Register of Deeds. I contacted the owner of the property. He said that he's...
The property, what are you talking about?
I'm sorry, the residence on Angel Street. He is the owner, listed owner. It is a rental property. When I talked to him, he said, I don't know who lives there. I have a rental company that takes care of all my rentals and provided information for me to contact them. I contacted the rental company and talked to Carrie Davis. Carrie is the property manager for, I'm sure, multiple properties for this owner. She looked it up and said that as of February 20th, as of February of 2020, Ms. Lopez had been the renter there. She is on a rental contract, which she provided us a copy, and also said when I asked her how she pays, she said that she pays every month with a credit card. I asked if she could tell me the name on the credit card, and it was Mrs. Lopez's name on the credit card.
So since February, she's been paying with her debit, credit card, whatever, each month using her own card. Is that accurate?
Yes, sir.
I know the final thing you did was talk to Ms. Lopez herself at her residence. Anything else, though, in the interim between the time you and Mr. Snyder, Investigator Snyder, were first notified of this by me to the time on Friday when you went to Ms. Lopez's house? Talked to the utilities, landowner, property owner, property management company, postal inspector, law enforcement in both K.S.A, where her former residence was, as well as law enforcement in Wichita, who has access to more utility information. Anything else? I want to make sure we put it all out there. Anything else that you and Investigator Snyder did prior to going to see Ms. Lopez on Friday?
That wraps it up. Yes, sir.
So then on Friday, this past Friday, I want to make sure I say this accurate, that would have been the 21st of August to 2020. Is that correct?
Correct.
What did you do?
Prior to that Friday, we contacted Ms. Lopez, obviously, and asked her if she would submit to an interview. She was very open to do that. And in fact, we went to her home on Angel Street to interview her there. She met us there at the appointed time, invited us into her home. Walking into the home, I did kind of a little walkthrough of the living area and the kitchen and a hallway, fully furnished, pictures of the kids on the wall. The kitchen was completely stocked. There was a dog present. We sat down in the kitchen and spoke with her. She was not angry at all. She was kind of perturbed that this was going on, but I think she kind of understood, and she was very cooperative. She talked about moving from K.S.A. back to the southwest part of Wichita. She explained to us that she grew up down there in southwest Wichita, has lived there for a long time, moved up to K.S.A. area for a family reason, and then moved back down to the southwest part of town. She has told us that she has no other place to stay except the house on Angel. She doesn't have another secondary residence. Kids are there. One of the allegations that showed up in an Eagle article in reference to this complaint.
I should ask, did you pay attention to the media coverage of this to see?
Yeah. To catch up on what the complaint was, there was an article in the Wichita Eagle, and I read that to kind of get more information. There was more information on the Eagle site than there was on the actual complaint. One of the allegations was that she was living in her boyfriend's home in the basement and was not paying any bills or paying any rent, and that absolutely is not, certainly in my investigation, there's no evidence of that whatsoever. We spoke to her for probably 20 minutes. Her attorney was present at the time. We explained how this was going to end up here. She answered every question that we had. Very cordial, very professional. The attorney was very helpful as well. And then that was kind of the closing of the investigation. There wasn't really anything else to do.
Okay. Did she, and I'm going to reference some language from the case law and the statutes I made reference to begin this hearing. Did she tell you whether or not she intended this residence on Angel Street did she view it as her permanent residence?
Yes, sir.
And did she tell you that she intended to, that she slept there and intended to return to there, at the end of each day?
Yes, sir.
Anything else with respect to Ms. Lopez and any information she provided to you and Investigator Snyder?
Just the interview, and that's all we needed.
That you described already.
Yes, sir.
Last question I have then is that address on Angel Street. First of all, it's in Sedgwick County. Is that correct?
Yes, sir.
And were you able to confirm with the Election Commission that it is or is not within District 2, the district that she is up for election this coming November?
It is in that district.
So in summary, the information you have is she moved in February, changed her utilities. She's been receiving mail there regularly since. And by all outward appearances, it appears she does live there. She claims to live there. Fully furnished house. I'm just hitting the high points here, but what I'm getting at is, did you find any indication that this candidate for office was not living within the district, either at the time she filed in May or certainly last week when you conducted your investigation?
No.
Okay. Ms. Greitz, any questions for Investigator Otis? Sheriff, you heard all that?
Yes, I did.
Any questions for
I have no further questions at all.
Okay. The statute is largely silent on the manner in which we conduct these hearings, but I think in fairness, I'll say it's now 10:32. We started on time with one technical glitch to allow Ms. Lopez time to jump on. But at 10:32, I don't see Mr. Whitmer or anyone else who's entered the room. But Ms. Yingling is present, Ms. Lopez's attorney. Do you have anything you'd like to ask Investigator Otis? I'll give you a moment to be heard here in a moment, but anything for the investigator?
I would just, for the record, or at least for the public, could you go through the other documents that Ms. Lopez provided you that day of the interview? And if not, I can
Ms.
say.
Ms. Lopez gave Investigator Snyder, I think it was a copy of her.
And just in case she's off, so Ms. Yingling was out, maybe away from the microphone for a minute, I'll just repeat what she said. She asked Investigator Otis to maybe just read for the public what documents at least Ms. Lopez provided to you and Investigator Snyder last Friday.
She provided a copy of her rental residential lease paperwork showing that she is the rentor of that address on Angel Street. It has a list of the deposit that was paid, the number of people in the residence, and it's signed by Ms. Lopez on February 20th of 2020.
Okay? Any other documentation she provided to you that you recall?
This is the only thing that I have.
And to clarify, did you all,
Hang on.
There's more pages if you flip out. It should be an enrollment form.
Yeah, oh, I'm sorry, that's right. There is, at the end of the lease, there's one more, maybe two more documents. One is her voter registration application that she moved from K.S.A. down to the southwest Wichita Angel Street on February 2nd of 2020. There's also a agency record, I'm not sure what this one is, but it shows that her new address is the Angel Street, not K.S.A. She has a Hayesville Unified School District receipt for paying enrollment fees for her children and a KG&E bill for the same address.
okay. Anything else? Yep. I don't think we have any additional questions based on, well, I'll just ask Sheriff or Ms. Greitz any additional questions based on that.
No, I don't. I do have one question. So whoever makes this complaint doesn't have to provide this administrative hearing any evidence of that they might have to even the reason why they filed a complaint. You can just say something and then it convenes this.
Yeah, the statute, again, is largely silent on this. It simply says that an objection thereto, if made in writing, within 3 days triggers this hearing. And simply says an objection. And I'm not going to read the whole statute into the well, publicly here, but I've read it several times, and there's very little threshold that's necessary to cause this hearing to be held. As long as an objection is made, the statute requires it to be considered. So, in answer to the sheriff's question, yes.
That's the only question I had.
Very
Thank
good.
you.
Investigator Otis, thank you very much.
Yes, sir.
In terms of, again, we're kind of flying without a net here in terms of really no guidance from the statute on the mechanism to hear this, meaning in a typical courtroom, there would be a burden of proof, there would be certain presumptions, etc. But if this were a civil matter, I think this would be almost at the stage where we would call this a summary judgment request. And try not to use too many legal words, but I've always found this term about as explicit as the law is capable of being, and that is, in a civil context, when someone sues somebody, makes an allegation against somebody, the first step is there's a summary judgment. The other side, the one who's being accused, has the power to say, and the term of art is this, that you have failed to state a claim upon which relief may be granted. You have failed to state anything that even gives rise to a justiciable action. And if that's the case, the judge in that kind of a context would simply dismiss the case, say it's a summary judgment. There's not enough even of a controversy to go forth to a trier of fact, a judge, a jury, etc. There's no guidance here on how we're to handle this, but I would say we at least ought to, if we're going to kick somebody off of an election, and take the public's ability to vote, for that individual away from the public, there needs to be at least some evidence of the same. I've not heard anything myself to suggest that we have evidence that Ms. Lopez was not and is not a resident of District 2. In fact, to the contrary, all the evidence that Investigator Otis found suggests that she was. The statute allows Ms. Greitz and myself and the sheriff to now conclude this. We'd leave the cameras on and we'd step to the other room. I'd call the sheriff in on a conference call, and we would examine this and make a decision and consider this. But, and I'm willing to do that. Sheriff, at this point, do you believe that further deliberation in a private setting is necessary?
Absolutely not.
Ms. Greitz, do you have any concerns at this point that there's weighing that needs to be done, a consideration that needs to be conducted?
I do not.
Okay. I don't mean to steal Ms. Yingling's thunder if she has something else she wants to add, but I think there's a final discussion to be had that I know you want to be heard on. But is there anything else you want us anything else you wanted to add? And if so, I'll have you step up to the microphone. But if there's anything else you want to add, let me know.
Not substantively, no.
Okay, not substantively was her answer if you couldn't hear from the back of the room. So at this point, Sheriff, do you, I guess to call the question here, we are to consider the controversy and whether or not Ms. Lopez can remain on the ballot. Do you have any reason to believe she should not be allowed to remain on the ballot?
No, I do not. I believe that we have rendered a decision that there is no evidence whatsoever that she does not live in the district. So therefore, I believe these proceedings should be closed. And our decision, or my decision on this is in Ms. Lopez's favor.
Okay, Ms. Greitz?
And I'm in agreement with Sheriff Easter.
Just so it's clear, since you're a little soft-spoken, you said you're in agreement with Sheriff Easter. Is that accurate? Thank you.
Yes.
I share the same opinion here. I'm here, obviously, we took this seriously. It was investigated by two investigators with, I happen to know, about 70 years of experience. I'm just going through this one last time. Last thing I'd point out is one statute I did not read in the record, 25407, the rule for determining the residence of a voter. Sort of vicariously, a voter turns into a candidate, and so while it says voter, it's essentially the same analysis. The judges of election in determining the residence of a person offering to vote shall be governed by this section. Residence means the place adopted by a person as such person's place of habitation, and to which, whenever such person is absent, such person has the intention of returning. I think that's utterly consistent with both the Attorney General's opinions and the 1950 decision that I read into the record earlier, but I wanted to that I read publicly, and I just wanted that added as well. So, and Ms. Lopez also stated as much, that this is what she considers her permanent residence. So, the order, and I have circulated already a pre-prepared order with both potentialities listed. I'll go back and correct that, and we will have that signed. And I guess, Ms. Greitz, there's not a case number here. There's not a filing with the district court, so there's not really a clerk to file it with, but I'll leave it with your office so that it's part of your permanent record, and I suspect would be available for review by the public. We should have that to you by noon tomorrow. The sheriff, I'll circulate it for your signature, the sheriff's signature, and I'll sign it myself to memorialize the hearing today. And it will show that Ms. Lopez she will remain on the ballot as a candidate for election this coming November. Finally, I know that Ms. Yingling did ask to be heard on one final matter. So, Ms. Yingling, I'd ask you to step up to where Mr. Investigator Otis was a moment ago so that you can be seen and heard as to your final comment.
Well, good morning, everyone. The authority of K.S.A. 25308 does give this board authority to grant costs in this matter. Generally, I think it is important for the public to question if someone lives in this district. However, it's clear, according to even Sheriff Easter's comments, that there is no due diligence done in this matter to ensure that this wasn't a waste of county resources and everyone's time here. As I listened today, 3 offices, if not 4, were involved in collecting evidence that wasn't provided to this body. And as well as my time I spoke with the elections office to get quorum material in order to defend this matter. There is some level of due diligence required at the state level to do this. I know because I've been involved in these matters before. For example, when I was on the legal team to challenge Mike Kapp's residency, we took several steps before filing an objection to ensure that we did not waste the state's time. The first thing that we did is we sent a letter to Mr. Kapp's, and that letter had a do not forward. That letter was returned to us. We also investigated personally both residences. The residence that he claimed in the district had long grass and had no evidence of his name on the house. However, if you went to his house out of district, the lawn and landscaping was perfect, and he had a capstone in his yard. Until we pointed this out, and he moved it to the house before the hearing. So today, we have anonymous witnesses that couldn't be bothered to show up despite how concerned they were about Ms. Lopez's residency. We have someone who accused Ms. Lopez, and by our investigator's own words, there was more information he gave to the Wichita Eagle than he gave this board. And as a radio host, what is his real motivation here? Is it content, or is it the voters of Sedgwick County? It's time to take a stand here today. What happens when some wild hair happens when somebody files an objection on everybody on the ballot and we have to sit up here for a week going through these hearings, as we are required to do? If you don't take a stand here today and say this is a waste of time and assess costs to Mr. Whitmer, he will have no repercussions and he will do this again. This is a very slippery slope. So I thank you for your summary judgment, but I think because of the nature of a summary judgment finding, it is appropriate to also assess costs to the county, Wichita Police Department, and my attorney's fees. Thank you.
Thank you. All right, so I appreciate your comments. I will read those. Legislative Coordinating Council versus Stanley for the 264 Kansas 690, a 1998 decision from the Kansas Supreme Court, wherein Justice Davis at the time held that costs and attorney's fees incurred in election contests were not campaign expenses, which could not be paid by a state officer. The phrase "all costs," in quotes, which were recoverable under election contest statute, do not include attorney's fees. Payment of attorney's fees incurred by LCC was authorized under the statute. Payment of costs and attorney's fees came within the scope of operational appropriation of the legislature. So it's a quick summary. I don't think that attorney's fees is something we can order. Again, well, you know, and then let me go back here. 25308. You did mention this, and it bears being read in here. Subsection E says the causes for objection under this section as to any office may be any of those listed in another statute's reference 25-1436. The officers determining an objection, so that'd be this body, the sheriff, Ms. Greitz, and myself, may assess any costs arising from such action to either the objector, in this case Mr. Whitmer, or the objectee, candidate Lopez, in accordance with the determination made. And then they would be paid to the election officer in this case. That's all the real guidance it gives. There's nothing that says what it can or can't be done. Investigator Otis, would you return to the lectern just for 1 second?
Yes, sir.
Did you and Investigator Snyder keep track roughly of the amount of hours the two of you combined put into this investigation?
We didn't log our time, but I believe a fair estimate would be between Investigator Snyder and myself, probably 3 to 4, maybe 5 hours, Thursday, Friday.
Okay. All right. Sheriff, any questions based on that?
So you're looking at the possibility of assessing those two investigators their hourly rate as the cost for conducting this investigation. Is that correct?
that, Ms. Yingling has essentially, I mean, she's asked for her attorney's fees. I don't think we have the power to do that, but she has asked also explicitly for the investigators' fees. And I think we're obliged not only to consider the objection, but also then any request for fees. And so I think that's the second part of our obligation here today.
Okay.
Mr. Bennett,
Mr. Stamper.
60-2001 deals with costs in a civil court context.
Well, you know what, Kevin, why don't you step up there? I'm not sure you can be heard. And identify yourself for viewers.
Kevin Stamper, Assistant County Counselor. K.S.A. 60-2001 deals with what are considered costs in a civil court context. Those have been deemed over the years to include things like the docket fee for filing a case, witness fees for subpoenas. There have been instances under which expert witness fees were recoverable to the extent that that testimony was used at trial. And I believe that those definitions of cost would be imported into this context.
Any advice, but do you, in your experience, have anything to offer in terms of what would be defensible under this statute in terms of types of, not so much a fee, exact amount, but what would be at least appropriate?
Generally, there is no guidance on that issue. I do know that attorney's fees have routinely been rejected in this context. I've fought for those myself in the past and not been able to obtain those, and I've also defended against such claims and prevailed on that. So,
In terms of investigative fees associated with investigations, and that I'll ask Ms. Greitz here in a moment about the election office's efforts as well, but would that be defensible in your opinion?
dealing with other costs, that is not included within that section. However, since this isn't exactly a civil court, I believe that you could construe that definition as you see fit.
Okay, thank you. Ms. Greitz, anything in terms of putting an hour, not so much on monetizing this, but in terms of how many hours were spent by your office on this effort?
As far as providing documentation, it was minimal. It's not something that we would have charged in a Cora request or anything.
Okay, thank you.
Other than that, it was just the time coordinating with the other members of the board today.
Okay, just again, so people can hear, just to make sure, you said minimal, sort of cost of doing business, normal work. Okay.
That's correct.
Okay, so I'll just say, knowing that this may come up, I wanted to have a sense of what, if I were to charge, let's say for a Cora request, somebody asked for an open records and asked my office to do an investigation, and if Investigator Otis was a part of that, Investigator Snyder, I went with the lower of the two, but it'd be about $35 an hour if I only used for one person, one of the two of them. And if he said 3, 4, 5 hours roughly is what you estimated, I'll just, give me 1 second. So, in that, I know that Clint had said it was about 6 hours for him. I know Kelly said he guesstimated 3, 4, 5 hours. But if we went with, yeah, 5 hours at $35 an hour, that'd be $175. Now, I'm not saying that would be appropriate, but Sheriff, any thoughts on that?
No, I think what you're talking about there is their hourly wage for two of them at how many hours they worked on this, correct?
Correct. And I'm frankly rounding down considerably. Ms. Greitz, any thoughts on that?
No, I think that is exactly the way our office would charge for much the same thing.
Okay. Well, just because, I mean, there are costs associated with, say, Cora requests. The statute does consider costs associated with this process, and that we do have the power, and it sounds to me like, reading the statute, we're obliged to at least consider whether costs are appropriate. And while I'm sure Ms. Yingling's hourly rate would be much higher, I don't think we have the power to speak to attorney's fees. But I think a $175 fee under the circumstances is not out of line. I will add, without much commentary, that Ms. Yingling does make a point, and that is that if there's no cost associated with doing this, we might find ourselves doing this in many other cases, and I don't certainly want to put a chilling effect on anyone's ability to raise a legitimate justiciable claim. If someone should not be on a ballot, there needs to be a mechanism to do that. If a candidate is not living in a district or the space that they claim to or need to, whether it's for state legislature or sheriff or district attorney, there needs to be a mechanism to do this. But at the same time, when fees are associated with something that, in this case, was so one-sided, I don't think that's out of line. So, Sheriff, if you, since we're not really following, this is not a court of record, I'll just ask, do you agree that a $175 fee, and asking Mr. Whitman to pay that is appropriate? Sheriff Easter?
In the context that, with core requests, those type of things, that we do charge for, in the fact of the matter on this, if there would have been anything that was brought to us other than, I think this is happening, then I would probably look at it differently. Clarify again what the 175 is. 75 is for the two investigators' time?
That's correct. So,
or the whole 175 is for the investigators' time?
The whole 175. So I took $35 an hour, which would be a little low, frankly, on Investigator Snyder's salary. I didn't charge it all for Kelly's. And at $5 hours, I'll just do the math one final time here. 5 times 35 is 175. And so,
okay, being
conservative on the amount, that's what we're considering. If that's appropriate, or if we just make it, yeah.
Well, again, I think that the fact of the matter is that, what I'm used to in court proceedings is one side gives their story, the other side gives their story, and then a judge or an administrative body makes a decision. In this particular case here, it's just an email saying this is going on with no proof of it whatsoever, and it costs your investigators to go out to investigate or to speak to Ms. Lopez, investigate it all, and I'm not sure that's appropriate, to be honest with you. So I would be okay with assessing the fine based upon those facts. Does that mean that I would assess it every single time? No.
Understood. That makes sense. Ms. Greitz, any additional comments?
Other than that, I feel it's completely appropriate as well.
Okay. I think we're unanimous on that. Don't want this to be usurious or draconian, but at the same time, and the next person, I don't want to dissuade anyone from making a legitimate claim, but I think the point the sheriff made is, if we had something to weigh here, if there was another side to the story, if something more specific had been brought, I get it, and we would do this without commentary. But when we have a situation where it's very one-sided, to dissuade that from happening in the future in other situations, I think a very modest fee like this is appropriate. So we'll make that a part of the order. I'll put that in and add that, and then circulate the order for Ms. Greit's signature, the sheriff's, and myself. Again, I'll then Once that's been signed by the three of us, submit that to the Election Commission, and I think that will conclude the efforts of this body today. If I have just 1 second. Ms. Greitz, anything else that you want to bring to my attention or for us to consider before we wrap this up?
No.
Okay. Sheriff?
I have nothing more, thank you.
Okay. So in summary, the conclusion of this body is that Ms. Lopez was a resident of the district in which she filed. Her name will remain on the ballot, and a $175 fee will be assessed under subsection E of the statute, and it will be payable to the election commissioner pursuant to this, this county election officer, I guess is what it says specifically, within the next 10 days. Well, I guess we'll make it 10 days from tomorrow, because that'll be the day the order is signed, and if we were in a courtroom, that's how we would typically tie it to, is the date that the document is signed. So, all right, with that, we will close this proceeding. I thank everyone for their time, and that'll be it. Thank you.
Thank you.